Okay, so in addition to the reforms in Singapore and in Hong Kong, what other jurisdictional developments are you seeing about funding elsewhere in the globe? I think the key ones that I've seen recently are in the Cayman Islands, where there's recently been a judgment from the courts that have actually endorsed and approved the use of funding, not just where claimants can't afford to pursue claims, but also where they're also a corporate that has money but just doesn't want to use it for funding. So it's approving funding now for corporates. Then also I've seen in Canada recent reforms to the class proceedings funds in relation to class actions in Ontario, where funding has been recommended to be expressly used in the new Class Proceedings Act as amended. What's important to funders when assessing risk and potential claims? I think the key one is, are you going to get paid? And will the defendant pay? That's different to, can the defendant pay? Defendants often have lots of money, but they choose to still try and avoid judgments or paying awards. So it's really understanding whether the defendant is somebody that is actually going to honour an award, and if not, understanding what the enforcement strategy is for ensuring that you can get that award or judgment monetised. How do funders approach investment claims as opposed to commercial arbitrations? I think there's probably not much difference. The key criteria that any funder will look at or should look at is, as I said before, can the defendant or will the defendant pay? Are there good legal merits? Is the costs against the claim value proportionate? And is there a good legal team on the case? But maybe specific to arbitration, you should also be looking at the seat of the arbitration and understanding that actually it's a good seat that recognises or doesn't expressly exclude using third-party funding, and then also making sure that there's a good set of procedural rules in place for the arbitration, which is going to be much more preferable than using funding an ad hoc arbitration. What are the top 3 things that you should consider when choosing to appoint a funder? So number 1 is the relationship. You're going to be in a relationship with this funder to pursue your claim, which could last anything between 2 and 4 years or even more, depending on what the claim is. You need to be so confident that you're actually going to be partnering with somebody who's going to be supporting you and actually who's going to be working with you and knows the risk of what they're funding. Secondly is the reliability. So making sure that your funder actually does have the funds to cover the costs of your claim right through to conclusion, because you don't want to get stranded halfway where funds have been used and the funder can't provide any further funding. And finally, it's the experience, making sure that your funder actually is experienced in litigation or arbitration in this case. So actually knowing how arbitration procedures work, knowing the jurisdictions of the claim that they're funding, and knowing the pitfalls and the highs and lows that arbitration can often go through, so that your funder doesn't just actually seek to take itself away from the relationship when things get tough.